Alrighty, so this is just We the People News. One more time at it. Never look straight forward. Always look around you. Be able to protect yourself by any means necessary, people. Alright, we're going to do part two of the Canon.
Educational, religious, charitable, fraternal or civic organization, but may be listed as an officer, director, delegate, or trustee of such an organization, and may be a speaker or a guest of honor at an organization's fundraising events. 3. A judge should not give investment advice to such an organization, but may serve on its board of directors or trustees even though it has the responsibility for approving investment decisions. D. Financial activities. 1. A judge shall refrain from financial and business dealings that tend to reflect adversely on the judge's impartiality, interfere with the proper performance of the judicial duties, exploit his or her judicial position, or involve the judge in frequent transactions with lawyers or persons likely to come before the court on which the judge serves. This limitation does not prohibit either a judge or candidate from soliciting funds for appropriate campaign or officeholder expenses as permitted by state law. 2. Subject to the requirements of subsection 1, a judge may hold and manage investments, including real estate, and engage in other remunerative activity including the operation of a business. A judge shall not be an officer, director, or manager of a publicly owned business. For purposes of this canon, a publicly owned business is a business having more than 10 owners who are not related to the judge by consanguinity or affinity within the third degree of relationship. 3. A judge should manage any investments and other economic interests to minimize the number of cases in which the judge is disqualified. As soon as the judge can do so without serious financial detriment, the judge should divest himself or herself of investments and other economic interests that might require frequent disqualification. A judge shall be informed about the judge's personal and fiduciary economic interests, and make a reasonable effort to be informed about the personal economic interests of any family member residing in the judge's household. 4. Neither a judge nor a family member residing in the judge's household shall accept a gift, bequest, favor, or loan from anyone except as follows. A. A judge may accept a gift incident to a public testimonial to the judge, books and other resource materials supplied by publishers on a complimentary basis for official use, or an invitation to the judge and spouse to attend a bar-related function or activity devoted to the improvement of the law, the legal system, or the administration of justice. B. A judge or family member residing in the judge's household may accept ordinary social hospitality, a gift, bequest, favor, or loan from a relative, a gift from a friend for a special occasion such as a wedding, engagement, anniversary, or birthday, if the gift is fairly commensurate with the occasion and the relationship. A loan from a lending institution in its regular course of business on the same terms generally available to persons who are not judges, or a scholarship or fellowship awarded on the same terms apply to other applicants. C. A judge or family member residing in the judge's household may accept any other gift, bequest, favor, or loan only if the donor is not a party or person whose interests have come or are likely to come before the judge. D. A gift, award, or benefit incident to the business, profession, or other separate activity of a spouse or other family member residing in the judge's household, including gifts, awards, and benefits for the use of both the spouse or other family member and the judge as spouse or family member, provided the gift, award, or benefit could not reasonably be perceived as intended to influence the judge in the performance of judicial duties. E. Fiduciary activities. 1. A judge shall not serve as executor, administrator, or other personal representative, trustee, guardian, attorney in fact, or other fiduciary, except for the estate, trust, or person of a member of the judge's family, and then only if such service will not interfere with the proper performance of judicial duties. 2. A judge shall not serve as a fiduciary if it is likely that the judge as a fiduciary will be engaged in proceedings that would ordinarily come before the judge, or if the estate, trust, or ward becomes involved in adversary proceedings in the court on which the judge serves or one under its appellate jurisdiction. 3. The same restrictions on financial activities that apply to a judge personally also apply to the judge while acting in a fiduciary capacity. F. Service as arbitrator or mediator. An active full-time judge shall not act as an arbitrator or mediator for compensation outside the judicial system, but a judge may encourage settlement in the performance of official duties. G. Practice of law. A judge shall not practice law except as permitted by statute or this code. Notwithstanding this prohibition, a judge may act pro se and may, without compensation, give legal advice to and draft or review documents for a member of the judge's family. H. Extrajudicial appointments. Except as otherwise provided by Constitution and statute, a judge should not accept.
We're going to pause right here. Along them lines, right? Attorneys and judges are bar members. Okay, so let's go with family court. All right, but you have all these attorneys out there donating money for when they're running for to be a judge. Because of them both being bar members, that is 100% conflict of interest. You guys know how I stand on it anyway if you watch previous videos, right? The whole court system is conflict of interest against you.
Appointment to a governmental committee, commission, or other position that is concerned with issues of fact or policy on matters other than the improvement of the law, the legal system, or the administration of justice. A judge, however, may represent his or her country, state, or locality on ceremonial occasions or in connection with historical, educational, and cultural activities. I. Compensation, reimbursement and reporting. 1. Compensation and reimbursement. A judge may receive compensation and reimbursement of expenses for the extrajudicial activities permitted by this code, if the source of such payments does not give the appearance of influencing the judge's performance of judicial duties or otherwise give the appearance of impropriety. A. Compensation shall not exceed a reasonable amount, nor shall it exceed what a person who is not a judge would receive for the same activity. B. Expense reimbursement shall be limited to the actual cost of travel, food, and lodging reasonably incurred by the judge and, where appropriate to the occasion, by the judge's family. Any payment in excess of such an amount is compensation. 2. Public reports. A judge shall file financial and other reports as required by law. Canon 5. Refraining from inappropriate political activity. 1. A judge or judicial candidate shall not I. Make pledges or promises of conduct in office regarding pending or impending cases, specific classes of cases, specific classes of litigants, or specific propositions of law that would suggest to a reasonable person that the judge is predisposed to a probable decision in cases within the scope of the pledge. 2. Knowingly or recklessly misrepresent the identity, qualifications, present position, or other fact concerning the candidate or an opponent. Or 3. Make a statement that would violate Canon 3b, 10. 2. A judge or judicial candidate shall not authorize the public use of his or her name endorsing another candidate for any public office, except that either may indicate support for a political party. A judge or judicial candidate may attend political events and express his or her views on political matters in accord with this canon and Canon 3b10. 3. A judge shall resign from judicial office upon becoming a candidate in a contested election for a non-judicial office, either in a primary or in a general or in a special election. A judge may continue to hold judicial office while being a candidate for election to, or serving as a delegate in a state constitutional convention, or while being a candidate for election to any judicial office. 4. A judge or judicial candidate subject to the Judicial Campaign Fairness Act, Texas. Election Code Paragraph 253.151, c. The act shall not knowingly commit an act for which he or she knows the act imposes a penalty. Contributions returned in accordance with sections 253.155 e, 253.157 b, or 253.160 b of the Act are not a violation of this paragraph. Canon 6. Compliance with the Code of Judicial Conduct. A. The following persons shall comply with all provisions of this code. 1. An active, full-time justice or judge of one of the following courts. A. The Supreme Court. B. The Court of Criminal Appeals. C. Courts of Appeals. D. District Courts. E. Criminal District Courts. And F. Statutory County Courts. 2. A full-time commissioner, master, magistrate, or referee of a court listed in 1 above. B. A county judge who performs judicial functions shall comply with all provisions of this code except the judge is not required to comply. 1. When engaged in duties which relate to the judge's role in the administration of the county. 2. With canons 4D2, 4D3, or 4H. 3. With Canon 4G, except practicing law in the court on which he or she serves or in any court subject to the appellate jurisdiction of the county court, or acting as a lawyer in a proceeding in which he or she has served as a judge or in any proceeding related thereto. 4. With Canon 5, 3. C. Justices of the Peace and Municipal Court Judges. 1. A justice of the peace or municipal court judge shall comply with all provisions of this code, except the judge is not required to comply. A. With Canon 3B, 8, pertaining to ex parte communications. In lieu thereof, a justice of the peace or municipal court judge shall comply with 6C, 2, below. B. With Canons 4D2, 4D3, 4E, or 4H. C. With Canon 4F. Unless the court on which the judge serves may have jurisdiction of the matter or parties involved in the arbitration or mediation. Or D. If an attorney, with Canon 4G, except practicing law in the court on which he or she serves, or acting as a lawyer in a proceeding in which he or she has served as a judge or in any proceeding related thereto. E. With Canons 5, 3. 2. A justice of the peace or municipal court judge, except as authorized by law, shall not directly or indirectly initiate, permit, nor consider ex parte or other communications concerning the merits of a pending judicial proceeding. This subsection does not prohibit communications concerning a. Uncontested administrative matters, b. Uncontested procedural matters, c. Magistrate duties and functions, d. Determining where jurisdiction of an impending claim or dispute may lie, e. Determining whether a claim or dispute might more appropriately be resolved in some other judicial or non-judicial forum, f. Mitigating circumstances following a plea of nolo contendere or guilty for a fine-only offense, or g. Any other matters where ex parte communications are contemplated or authorized by law. D. A part-time commissioner, master, magistrate, or referee of a court listed in 6A, 1 above. 1. Shall comply with all provisions of this code, except he or she is not required to comply with Canons 4D2, 4E, 4F, 4G or 4H, and 2. Should not practice law in the court which he or she serves or in any court subject to the appellate jurisdiction of the court which he or she serves, or act as a lawyer in a proceeding in which he or she has served as a commissioner, master, magistrate, or referee, or in any other proceeding related thereto. E. A judge pro tempore, while acting as such, 1. Shall comply with all provisions of this code applicable to the court on which he or she is serving, except he or she is not required to comply with Canons 4D2, 4D3, 4E, 4F, 4G or 4H, and 2. After serving as a judge pro tempore, should not act as a lawyer in a proceeding in which he or she has served as a judge or in any other proceeding related thereto. F. A senior judge, or former appellate or district judge, or retired or former statutory county court judge who is consented to be subject to assignment as a judicial officer, 1. Shall comply with all the provisions of this code except he or she is not required to comply with Canon 4D2, 4E, 4F, 4G, or 4H, but 2. Should refrain from judicial service during the period of an extrajudicial appointment not permitted by Canon 4H. G. Candidates for judicial office. 1. Any person seeking elective judicial office listed in Canon 6A, 1, shall be subject to the same standards of Canon 5 that are required of members of the judiciary. 2. Any judge who violates this code shall be subject to sanctions by the State Commission on Judicial Conduct. 3. Any lawyer who is a candidate seeking judicial office who violates Canon 5 or other relevant provisions of this code is subject to disciplinary action by the State Bar of Texas. 4. The conduct of any other candidate for elective judicial office, not subject to paragraphs 2 and 3 of this section, who violates Canon 5 or other relevant provisions of the code is subject to review by the Secretary of State, the Attorney General, or the local district attorney for appropriate action. H. Attorneys. Any lawyer who contributes to the violation of Canons 3B7, 3B10, 4D4, 5, or 6C2, or other relevant provisions of this code, is subject to disciplinary action by the State Bar of Texas. Canon 7. Effective date of compliance. A person to whom this code becomes applicable should arrange his or her affairs as soon as reasonably possible to comply with it. Canon 8. Construction and terminology of the code. A. Construction. The Code of Judicial Conduct is intended to establish basic standards for ethical conduct of judges. It consists of specific rules set forth in sections under broad captions called canons. The sections are rules of reason, which should be applied consistent with constitutional requirements, statutes, other court rules and decisional law, and in the context of all relevant circumstances. The code is to be construed so as not to impinge on the essential independence of judges in making judicial decisions. The code is designed to provide guidance to judges and candidates for judicial office and to provide a structure for regulating conduct through the State Commission on Judicial Conduct. It is not designed or intended as a basis for civil liability or criminal prosecution. Furthermore, the purpose of the code would be subverted if the code were invoked by lawyers for mere tactical advantage in a proceeding. It is not intended, however, that every transgression will result in disciplinary action. Whether disciplinary action is appropriate, and the degree of discipline to be imposed, should be determined through reasonable and reasoned application of the text, and should depend on such factors as the seriousness of the transgression, whether there is a pattern of improper activity and the effect of the improper activity on others or on the judicial system. B. Terminology. 1. Shall or shall not denotes binding obligations, the violation of which can result in disciplinary action. 2. Should or should not relates to aspirational goals and as a statement of what is or is not appropriate conduct, but not as a binding rule under which a judge may be disciplined. 3. May denotes permissible discretion or, depending on the context, refers to action that is not covered by specific proscriptions. 4. De minimis denotes an insignificant interest that could not raise reasonable question as to a judge's impartiality. 5. Economic interest denotes ownership of a more than de minimis legal or equitable interest, or relationship as officer, director, advisor or other active participant in the affairs of a party, except that ownership of an interest in a mutual or common investment fund that holds securities is not an economic interest in such securities unless the judge participates in the management of the fund or a proceeding pending or impending before the judge could substantially affect the value of the interest. 2. Service by a judge as an officer, director, advisor or other active participant in an educational, religious, charitable, fraternal, or civic organization, or service by a judge or spouse, parent or child as an officer, director, advisor or other active participant in any organization does not create an economic interest in securities held by that organization. 3. A deposit in a financial institution, the proprietary interest of a policyholder in a mutual insurance company, of a depositor in a mutual savings association, or of a member in a credit union, or similar proprietary interest, is not an economic interest in the organization unless a proceeding pending or impending before the judge could substantially affect the value of the interest. And 4. Ownership of government securities is not an economic interest in the issuer unless a proceeding pending or impending before the judge could substantially affect the value of the securities. 6. Fiduciary includes such relationships as executor, administrator, trustee, and guardian. 7. Knowingly, knowledge, known, or knows, denotes actual knowledge of the fact in question. A person's knowledge may be inferred from circumstances. 8. Law denotes court rules as well as statutes, constitutional provisions, and decisional law. 9. Member of the judges or the candidate's family denotes a spouse, child, grandchild, parent, grandparent, or other relative or person with whom the candidate maintains a close familial relationship. 10. Family member residing in the judge's household means any relative of the judge by blood or marriage, or a person treated by a judge as a member of the judge's family, who resides at the judge's household. 11. Require. The rules prescribing that a judge require certain conduct of others are, like all of the rules in this code, rules of reason. The use of the term require in that context means a judge is to exercise reasonable direction and control over the conduct of those persons subject to the judge's direction and control. 12. Third degree of relationship. The following persons are relatives within the third degree of relationship: great-grandparent, grandparent, parent, uncle, and brother, sister, child, grandchild, great-grandchild, nephew or niece. 13. Retired judge means a person who receives from the Texas Judicial Retirement System, Plan 1 or Plan 2, an annuity based on service that was credited to the system. Sections 831.001 and 836.001, VTCA Government Code, Chapter 179, Section 1, 71st Legislature, 1989. 14. Senior judge means a retired appellate or district judge who has consented to be subject to assignment pursuant to Section 75.001, Government Code. Chapter 359, 69th Legislature, Reg. Session, 1985. 15. Statutory county court judge means the judge of a county court created by the legislature under Article V, Section 1, of the Texas Constitution, including county courts at law, statutory probate courts, county criminal courts of appeals, and county civil courts at law. Section 21.009, VTCA Government Code, Chapter 2, Section 1601, 18, 71st Legislature, 1989. 16. County judge means the judge of the county court created in each county by Article V, Section 15, of the Texas Constitution. Section 21.009, VTCA Government Code, Chapter 2, Section 1601, 18, 71st Legislature, 1989. 17. Part-time means service on a continuing or periodic basis, but with permission by law to devote time to some other profession or occupation, and for which the compensation for that reason is less than that for full-time service. 18. Judge pro tempore means a person who is appointed to act temporarily as a judge.
Alrighty, there we go. These are We the People News. Till next time. Bye, y'all.